information to the credit reporting agencies, they are the furnishers. They're the ones who are providing this information to them. And so this is a payment or balance inaccuracy. And this is, again, you have to ask yourself, is it inaccurate? And why is it inaccurate? Was there a bankruptcy? Was it post-bankruptcy? Was it settled or was it dismissed? Is there a modified mortgage, or is there any other substantive relief? I should say relief, not belief. Any other substantive relief for that debt? So it's really important to understand what is wrong with the trade line as it appears on the credit report. Okay, that is the most important thing to think about. What is wrong with the credit report as it appears? If you're telling me that the account was paid, then you should have some sort of proof. If you're telling me the account, the account is not his account at all, and it's somebody else's account, then there should be something that's related to it. And of course, more disputes help. And this adds to the value of these cases, because as you are providing more notice to the credit reporting agencies of the inaccuracy as it appears, and the furnishers are also, possibly verifying this inaccurate information, that adds to the willful non-compliance of the Fair Credit Reporting Act, which leads to increase in damages. So it's a fine balancing act. Again, it's a very complex legal analysis of what these cases are actually worth. But the more disputes that you have, the more potential value there is, because you have provided more notice to the credit reporting agencies as well as the furnisher about the inaccuracy as it appears in your credit report. And so there are oftentimes resolved debt cases. And what do I mean by this? This is, let's say you settle a debt pre-litigation. So if a consumer has a debt that they have not been sued for, that is non-litigation. Then if you're helping a consumer resolve that debt, let's say it's pre-suit and it's against the debt collector, and let's say it's $2,000 and you settled for $1,200, there is that and that $800 difference, if that's being reported on a credit report, this happens all the time in these types of resolved debt cases, where a debt that may have been resolved continues to report inaccurately on a credit report, despite the fact that proof or evidence has been provided. This also happens a lot in the collection defense industry, or kind of in the space. And actually, we just had a case about this just this week, where a dismissal, when a creditor sues a consumer in court, and then the creditor loses and the case is dismissed, that means that the consumer does not owe that debt anymore. And so it should not be appearing on the credit report. If it's been dismissed, and if the consumer won the case, then the consumer no longer owes the debt. And therefore, it's very important to see if there was a dismissal, or if there was a stipulation or a settlement agreement with release, so that you can see where the consumer's rights are. Did the consumer agree that the account would be deleted off the credit report as part of a settlement agreement? And if they did, then you can dispute that the account is still appearing on the credit report to the credit reporting agencies if you are trying to recover, or if you're trying to get it deleted, off the consumer's credit report. Again, this also happens a lot in the foreclosure defense and loss mitigation space, and this is going to be something that's going to be really an up-and-coming area over the next 2 to 5 years, where there's going to be, again, we're going to be seeing a lot of foreclosures and a lot of foreclosure defense going on. And we're also going to be seeing a lot of loss mitigation, which is someone getting a loan modification on their home. It's during this time, during a lot of these situations with foreclosures or loan mods or bankruptcies or whatever, there's a lot of credit reporting implications